Okay, thank you, Mr. Chairman, members of the committee. Again, I'm Paul Neal, committee staff, and this is Medicare Briefing. Again, this is a follow-up on the work that came out of House Bill 1868 that I already talked about. Going back to where this started, in the 2009 interim, this committee did quite a bit of work on this issue of providing medical coverage for catastrophically disabled Left 2 members after retirement. The issue, one of the issues that came out of that was there was this policy desire to do that, but there was also a competing balancing thing of you want to make sure you've got some kind of control on the costs and aren't just saying, you know, go out and get insurance and we'll pay for it. So the balance that was struck by the board was to provide it as a reimbursement. And in doing that reimbursement, the bill proposed by the board and passed by the legislature identified sources where post-retirement medical could be provided for a retiree, and then cited those in the bills. The first one is COBRA, that essentially pretty much everybody gets for 18 months and potentially 29. And then there's employer-provided post-retirement medical. And again, in most cases, this is not the employer paying. This is just allowing the retiree to remain in the risk pool and self-pay their premium as part of the risk pool and have a somewhat lower premium that way. That's that varies by employer. It's usually a bargain issue. And then there's Medicare, which for anybody who was first hired after April of 1986, they would have to be in Medicare. So that was thought that covered the waterfront pretty well. What we discovered in January was that there was a group of employees who don't have any of those, or at least once their COBRA runs out, they don't have any. And again, this was, you've heard of Win Loyland, who ended up 1868 was named after him. He was a Left 2 firefighter, was injured on duty, catastrophically disabled. After his COBRA ran out, they found out that his employer didn't provide post-retirement medical, and he did not have Medicare because he was in a group of people that was first employed prior to April of '86 and had been continuously employed since that time. So, as part of that process of dealing with 1868, legislative staff reached out to DRS and the Actuary's office and this staff, because we had done a lot of the groundwork in getting this put together, to try to figure out how big this group of people was. And what we found out, mostly with the help of DRS, was trying to figure out, like, how big is this group of people. So we started out with here. By definition, this has got to be people who've been continuously employed with the same employer since before April of '86. And so we started with that group of people, and then of those, how many had no employer Medicare prior to '86, and Medicare is tied to Social Security. Roughly, from earlier research by the board, about half of firefighters have Social Security, and about half of law enforcement officers, and only about 10% of firefighters. So came up with a solid number of 600, and then we were unsure if the employer provided Medicare pre-'86 for another 420. That number got peeled back a little bit because there was, I believe it was in 2009, there was a divided referendum process that was authorized where an employer could allow non-Medicare employees to opt into Medicare, and about 44 did that, so that dropped it down. I've got a question mark in the last box because the thing we don't really know is if members that fall into this category otherwise might have 40 quarters of Social Security employment elsewhere. So what we came up with was about 1,000 folks out of this process who were potentially covered, and then applying the assumptions about disability, catastrophic disability incurrence. We came up with about one person every 3 years would have been potentially affected, would have been potentially fallen outside the scope of the original bill. The Actuary's office did a fiscal note on that and identified a cost, but it wasn't enough to affect rates, and the bill was passed and signed by the governor. There are a couple of issues with the costing. Any time you're doing a fiscal note, you can pretty much guarantee that the number is going to be wrong because it's an estimate. And so, in keeping with good practice, I think we erred on the side of over-inclusion, so that we didn't understate the cost, so the cost wasn't understated. I think the biggest problem was that we weren't able to reliably identify employees whose employer provided post-retirement medical. Now, we did a survey back in 2005 that asked and answered that question, so we had data, but that was old enough that it really just wasn't reliable enough to use for fiscal analysis. But certainly of those 1,000 people identified, some of them are going to have employer-provided post-retirement medical, so they would drop off the list. We just don't know how many. We didn't have a reliable estimate, so we didn't want to go with potentially misleading number. Another issue with the identification of these folks is that, by definition, you're talking about firefighters and law enforcement officers who've been at the job at least 27 years, and some certainly more. So that kind of cuts both ways, because in that age group, the probability of service retirement is quite a bit higher. So obviously, they take a service retirement, then they're no longer part of the group. On the other hand, people in older age brackets have a higher possibility of becoming disabled. So kind of cuts both ways. Not sure where that ends up, but I think one thing that is true is that within 10 years, all these folks are going to be retired one way or the other. So there won't be any additional people after that time who would be in need of the provisions of 1868. So there's not really anything you have to do about this. This is just an update because this issue, we didn't have an opportunity to brief you about it before session because it didn't come up. At most, you might want to think about whether you want to update the data so we have more recent data. So if this comes up again, we'd be able to have some better numbers.
So what we're trying to identify is of 1,000 potential, narrow that down to what it really is, and then of them, estimate how many will seek a catastrophic disability.
Right. You get your base number, then apply that percentage.
And
assumption.
your best Kentucky windage on that is a couple a year.
Yeah. Well, right now it's about 1 every 3 years, given the 1,000
that's right,
number.
1 every
so
3 years.
if the data from 2005 was still accurate and roughly about half of employers provided post-retirement medical, then maybe that would become 1 every 5 or 6 years. But in either case, it's not enough to affect rates.
I have a question about employer-provided post-retirement medical insurance. I'm aware of a number of groups that, through their collective bargaining agreement with their employer, the unions have actually taken over the provision of medical insurance. Mm-hmm. So I'm wondering if that would qualify. So the number of groups out there have union trusts that actually manage the health care for their employees. Would that qualify? Would those people qualify for employer-provided post-retirement medical insurance?
That would be actually subject to whatever the agreement was. For instance, in Wynn's case, that's exactly what had happened, but the medical didn't allow retirees to continue to be a part of it.
That particular trust didn't allow that functionality? Okay.
Yeah, so that would be sort of depending on how it was set up, whether or not retirees were allowed to continue in it or not.
But if the trust allowed that, then
yes,
they would qualify under the employer-provided?
Yes.
Okay.
As long as it's something that was bargained for with the employer,
okay,
that the employer agreed to.
Okay, any other questions? Okay, thank you, Paul.
Thank you.